Bismillah, alhamdulillah, wassalamu ala rasulillah wa ala alihi wa sahbihi wa man wala, thumma amma ba'd. To proceed. Today, inshallah, we will finish the second minor legal maxim, al-tabi', the dependent follows. The dependent follows. This is the second after which one? Al-a'mal awla min al-ihmal. Application is preferred to negligence. So, the second one, al-tabi', the dependent follows. We started the subsidiary maxims under the second minor maxim, and we said that these two maxims in particular look a lot more like the major maxims because they even have many subsidiary maxims. Today, inshallah, we'll try to finish the subsidiary maxims under at-tabi'. The first one we will address is يغتفر في التابع ما لا يغتفر في المتبوع. Dispensations are allowed in the subsidiary that are not allowed in the principal. Imam ibn al-Qayyim said ويغتفر فيما دخل ضمنا وتبعا ما لا يغتفر في الأصول والمتبوعات. Concessions are granted in what enters incidentally and as a subsidiary that are not granted in the principals and the independents. This is very close to which qaida? يثبت تبعا ما لا يثبت استقلالا, which would mean what cannot be established independently may be established as a subsidiary. So you may feel some resemblance between the examples that we will give to this qaida or about this qaida and the previous qaida. Imam Taymiyyah rahimahullah said the Prophet sallallahu alaihi wasallam permitted when selling pollinated date palms that the buyer stipulate ownership of the fruit. This would otherwise not be allowed, right? So he goes on to saying that this is there is some gharar here or uncertainty here, but this was permitted incidentally and as a subsidiary in a way that is not permitted independently. Do you remember this example? Like when we said that you could sell the date palm trees. You could sell the date palm trees, and the buyer can stipulate that he will get the fruits as well. These fruits have not ripened yet. They would not be permissible to sell independently, but we allowed them to be sold with the palm trees. Why? Because in this case, they are not the principal subject of the contract. They are a subsidiary. He goes on to say that the harm of gharar is less than that of riba. For this reason, concession is granted in cases where there is a need. Whenever prohibiting it would create a greater sort of harm or difficulty. That is why, if you buy a home, you don't actually check out the foundation and the interiors of the walls. And when you buy a cloak, you don't check out the lining or the sort of the hash of the cloak. And likewise, when you buy a sheep, when you buy shat laban that has a lot of milk, you can buy the goat or the sheep that has a lot of milk and up the price for the milk, whereas you cannot buy the milk in the others independently. So if you buy the sheep, just like buying a pregnant sheep, up the price for the fetus, but you cannot buy the sheep, the fetus independently. The waqf of movables. In the Hanbali madhab, can you make waqf of movables, or is waqf only limited to real estate? Can you make waqf of movables? And make waqf of furnishings, furniture? Can you make waqf of furniture? Yes. Keep in mind that we have two different positions on this. One says yes, and this one is in agreement with the Malikis and Shafi'is. One says no, and this one is in agreement with the Hanafis. So you cannot make waqf of movables according to one position in the madhab. But according to that position in the madhab, and the Hanafis also, who said you cannot make waqf of movables, they get around this when you make waqf of a house and the movables inside the house by saying, yes, you can make waqf of the movables in this case, because the movables are not the principal. They are the subsidiary. Therefore, you can make waqf of movables as the subsidiary. Another example, the object of a lease. The object of a lease cannot be basically exhaustible. The object of a lease cannot be exhaustible, because when you lease something, you're buying what? The usufruct, the benefit, not the actual thing. So you cannot lease basically fruits to be eaten, because like that's not a lease. So we cannot basically conclude it. It is concluded on its benefits that can be utilized, not the substance itself. So it's not, but the water collected in a well, for instance, is it permissible to lease a well to basically use the water? The water is exhaustible. You're leasing the well, but you will be using the water which is exhaustible. Yes, it is, because in this case, the water is subsidiary to the well. The water is subsidiary to the well. When you hire a doctor, that the sutures that they will use, the ointments that they will use, that can be part of the hiring. That could be part of the hiring, and it would be permissible in this case. So he's saying that this is just like the ink with this, the water in the well is like the ink of the scribe, the ointment of the physician, and so on and so forth. Another issue also, which يغتفر طبعا ما لا يغتفر استقلالا. So more concessions will be given to the subsidiary that are not given to the principal. Is the issue of tatarrus, human shields. If the enemy uses human shields, we know that targeting those individuals is not permissible. We know that targeting those individuals is not permissible. If they use their children and women as human shields, it's not permissible to target. But would it be permissible to basically not target them, however, to sort of launch attacks at the enemy despite the presence of human shields? They said yes, and they said this is a case of a subsidiary. Even if they have Muslims that they're using as human shields, and the cost of basically refraining from targeting the sort of the enemy will be a high cost, then you could certainly do this even in the presence of Muslims within the enemy ranks. In contemporary contracts, insurance on so one contemporary example, because your brain is fried from all the classical examples. So if you buy a fridge and they offer you a warranty with the fridge, if you walk out, you buy a fridge, you take it home, and then someone calls you and offers you a warranty. Keep in mind, insurance and warranties, and these are matters of controversy. However, the vast majority of scholars do not allow conventional insurance. We're going by the vast majority of scholars. But if you ask some scholars about, insurance in general as a concept, they'll be quite permissive about it. But we're going by the vast majority of contemporary scholars who would not allow conventional insurance. They would allow cooperative insurance, تضامني, تكافلي, تعاوني, which is called Islami. Cooperative insurance, but they wouldn't allow conventional insurance. So the warranty here is a form of conventional insurance or not? Conventional insurance. You pay $3, everybody, how do you change this? Everybody pays $3 a month, and whoever, everybody is paying $3 a month, and if you need your fridge repaired, you get your fridge repaired. It's just the very same idea like insurance. Warranty is an insurance. So now that you had bought the fridge and you're home now, and someone calls you and tells you, we offer you this warranty, permissible or impermissible? Impermissible. Why? Because this is an independent contract, independent insurance contract. We've talked about insurance before. We've talked about insurance being permitted for haja, and for like a need, for a significant need. So so if you have health insurance, you probably need to have health insurance. Don't worry about it. If you have comprehensive on your car because you cannot basically handle the loss of your car, it will be a hardship. If it's lost, then you can have your comprehensive on your car, and so on. But by default, insurance, conventional insurance is not permitted. Warranty is like that. So what if you have not left Best Buy yet, and you're still at the cashier, and they offered you a warranty? Can you take it? Yes, you can. Yeah. That's the whole, you're going to ruin the قاعدة itself. The قاعدة says يغتفر طبعا ما لا يغتفر استقلالا. So we will allow here concessions regarding this, because this is now being a subsidiary to the contract. A subsidiary to the contract. It is like you are basically buying a product with a condition, with an extra sort of condition that it will be fixed within the next 3 years if it is broken, within the next 3 years. So in this case, then the warranty would be permitted. Next is قد يغتفر. Yeah. You cannot get the warranty after that. Oh. As a subsidiary to the contract, as part of the contract, the first contract that you're signing with them, that may be allowed on the same basis. Yeah. No, because the difference between that example and the cooperative insurance is that with that example of conventional insurance, you have two parties. You have the company on this side, and you have the clients on this side. and the company is collecting the $3 and $3 and $3 and $3. If no fridge gets broken, the company makes a lot of money. If a lot of fridges get broken, the company loses a lot of money. So this agreement between the company and the clients is an agreement of undue risk-taking or gharar. That makes it basically an impermissible agreement. The difference with cooperative insurance, you don't have a company here. You have a pool, $3, $3, $3, $3. If fridges do not get broken, we will have surplus. The surplus will go back to the clients. If many fridges get broken, you will have a deficit. The deficit will be shouldered by the clients. So who's running this? A company. What is the difference between this company and this company? This is a non-for-profit company. They get basically salaries. It's not a non-for-profit company. They get salaries. So the surplus and the deficit, it doesn't matter to them. They're getting salaries. Okay. قد يغتفر في البقاء ما لا يغتفر في الابتداء. In continuation, what would not be allowed at initiation may be tolerated. And as we said before, any maxim that starts with qad, that has may, is controversial to begin with. Controversial whether we can call this a maxim or not, because a maxim should be consistent. And if you need to say qad or maybe, then that is the epitome of inconsistency. So can you call this a maxim? And I told you that the reason why I am including them as maxims is to point to the concept itself. The concept is that it is not always consistent, that in continuation, what would not be allowed at initiation will be tolerated. It says may be tolerated to point you to the fact that is the maxim here, that continuation is easier than initiation. You have more stringent criteria at initiation than you have in continuation, and we will give some examples. Okay, so let's start by this qaida, the seventh qaida of al-Qawaaid of Imam ibn Rajab, rahimahullah. He says, من تلبس بعبادة ثم وجد قبل فراغها ما لو كان واجدا له قبل الشروع لكان هو الواجب دون ما تلبس به هل يلزمه الانتقال إليه أم يمضي ويجزئه. If one engages in an active worship, then before completing it encounters something that, had he found it before beginning, would have been obligatory instead of what he is performing. Is he required to transition to it? Is he required to transition to it? One example is, and he makes a distinction here between whether the substitute is legislated as a general concession or as a necessity. So permitted as general concession. If you're making tamattu in Hajj and you don't have money to slaughter for tamattu, a sheep, can you fast? Yes, you can fast. Is this a general concession? Yes, it is a general concession. Then, what if you started to fast and then you find the money, or you found a sheep or something? Do you need to slaughter now, or can you just carry on with your fasting? After starting, you can carry on with your fasting. You don't need to go back and slaughter the sheep. Now, on the opposite side of this, things that are legislated due to absolute necessity. Women, for instance, how do they count their period? Women during the sort of menopausal women, how do they count their period? By months. What if you have sort of interruption of the periods and you count the periods, let us say young women, how would they count their period before they have menstruation? Just like older women, by months. And so let's say you're counting your periods by months, and then you start to have your periods. Can you carry on counting by months, lunar months, or should you now switch to counting by the periods? You must switch to counting by the periods, because counting by the lunar months is only permissible for women who don't have a period. But between these two examples, there are others that would be a little bit controversial. So let's take some of these. One who begins fasting for an expiation, kaffara, whether it is zihar or kaffara for an oath, and then finds a slave. What is the kaffara of zihar? You have to free a slave. What if you can't? Fast. Okay. What if you can't? Correct. So what is the kaffara of yameen? Have to free a slave. But the fasting is quite different. From 3, it's, like 60 to 3 days. It's quite different, in terms of fasting for zihar and an oath. But the first one for both is free a slave. Free a slave. And as if Allah subhanahu wa ta'ala, the tashawuf al-shara ila al-hurriya, the shara eagerness for hurriya, he just wanted to free the slave up there. Although the Sharia recognizes the huge difference between zihar and the oath, it's quite obvious. In the second in line, the obligation is just quite different. But the Sharia wanted to free a slave up there so that anyone who can free a slave will free a slave. Anyway, but like in zihar and the yameen, if you don't have the slave and you start fasting, and then you find the slave, what do? Okay, so because it's a little bit more complicated, they will disagree in the madhab, but you can actually carry on. You don't have to stop your fasting. You can carry on according to the mu'tamad of the madhab. And they said that this is akin to fasting of a mutamatta. But there is another position in the madhab that says this is a kaffara. This is an expiation. This is a disciplinary action. This is not tamattu. Tamattu, the guy didn't do anything wrong. The guy just made tamattu, which is, the preferable mode of Hajj and Umrah. At least, according to some. But tamattu, the guy didn't do anything wrong in tamattu. So it is okay to basically consider it a concession with respect to tamattu. But here, this is an expiation for a violation of an oath or zihar, which is forbidden. So it's a disciplinary action, should not be treated with leniency. So the other position in the madhab is he has to go back and free a slave. He cannot continue with his fasting. Now, if one begins prayer with tayammum, then finds water, what does he do? If you say يغتفر في البقاء ما لا يغتفر في البقاء ما لا يغتفر في الابتداء, more leniency will be shown in continuation, then you will say, just let him carry on with his prayer. And this is a position in the madhab. But the dominant position in the madhab is different from that. They want you to end your prayer, make wudu, since you found water. And this is based on what? Why is this istithna, or exception? from the qaida, because the qaida is saying, well, he just started, let him finish, because يغتفر في البقاء ما لا يغتفر في الابتداء. But why are we making an exception from the qaida? Because in the madhab, tayammum is rafi' وليس is مبيح وليس رافعا. Tayammum allows you to pray, but does not remove your impurity. It doesn't remove your impurity. It just allows you to, this is like you may think it's a hypothetical, theoretical issue, but it's consequential. You know, Allah allowed us to make tayammum and pray. So the scholars now are disagreeing. Does that mean that tayammum removes your impurity? Or does it mean that you're allowed to pray despite having the impurity? So that's the big disagreement. In the madhab, the dominant position in the madhab is that tayammum is mubih. It allows you to pray, not rafa. It does not remove, lift, your impurity. That's a controversial issue. And if you feel otherwise, that is fine. I may feel otherwise as well, but that's fine. Yes. Yeah. So now the next one is if you have noticed that the last, okay, let's get this one, this other exception. If a man embraces Islam while married to a Magian woman, does he have to, can they carry on, or does he have to divorce her? Well, he has to divorce her, because he's not allowed to be married to anyone but Muslim or Christian or Jew. One of the exceptions also, there are many exceptions. So you get the point, that this qaida is not consistent all the time. Because if it was consistent all the time, we would have said to the guy who started the prayer, carry on. We're not saying to him, carry on. We're saying, end your prayer and make wudu. We would have said to that man who's married to a Magian, all right, continuation is easier than initiation, but we didn't. We didn't say that. We told him to divorce, not divorce, to leave his wife. Now, the next one is التابع يسقط بسقوط المتبوع. The subsidiary lapses with the lapse of the principal. The subsidiary lapses with the lapse of the principal. And they usually give you the sort of the justification that, you cannot imagine branches without trunk, right? There has to be a trunk to imagine the branches. The most important application is the nullification of deeds with the nullification of faith. يسقط الأصل يسقط التابع يسقط بسقوط المتبوع. The subsidiary lapses with the lapse of the principal. So all the deeds are nullified when faith is nullified. Prayer of a follower, we discussed this before, that when you break your wudu as an imam, in the madhab, there is no succession. Most of the scholars nowadays believe in succession. And that seems to be the position of the majority. So if you're the imam and you break your wudu, should you grab someone to carry on with the prayer? Most of the scholars will say yes nowadays. In the madhab, that is incorrect. In the madhab means what? In the mu'tamad, in the official position of the madhab, that is not correct. If your prayer is nullified as an imam, everybody's prayer is nullified. Okay. If you're incapable, here's another example. If you're incapable of prostrating with the forehead, do you have to basically, like, what are the limbs of prostration, or the sort of the spots of prostration, a'dha as-sujud, or the spots that you need to prostrate on? Aren't they 7? Yes. So your toes, your knees, your hands, 6, and your forehead, 7. Okay. So you can't prostrate, you can't put your forehead on the ground. Should you put your hands on the ground? No. They said you don't need to put your hands on the ground. Why? Because al-asl, is the forehead. And if al-asl drops, the subsidiary drops. Prostration is meant for what? For you to put your forehead on the ground. The hand is assisting you to put your forehead on the ground. And if you can't put your forehead on the ground, you don't need to put your hand on the ground. We will have another qaida that says al-maysur la yasqut bil-ma'sur, which means that which is attainable is not dropped by that which is unattainable. And you will have examples in this qaida that would look like the opposite of the examples that were given here. However, the distinction will be what? That we will address the distinction with qa'idat al-maysur la yasqut bil-ma'sur. But here, the point that we're trying to make here is that the whole point of sujood, this subsidiary is not intended for itself. It is not part of the ibadah. Putting my hands on the ground is not intended for itself. It doesn't have a virtue, an independent virtue. It is to assist me to put my forehead on the ground. So if I can't put my forehead on the ground, why do I need to put my hands on the ground if it doesn't have any inherent virtue? Okay, now, so custody cases, let's take an example from a custody case. If I am the father and I drop my custody, or I am, abandon the custody of my children, do my relatives lose the right to custody? Yes. Okay, and that is a position in the madhab. However, the formal position of the madhab is, no, they don't. So this would be an exception from the qaida, or consistent with the qaida, an exception from the qaida. Because here, al-asl dropped, and al-fara', the branch, was not dropped. So my relatives can still ask for custody. Okay, the right of custody. The liability of the one on whose behalf a guarantor stands. Oh, okay. If you guarantee someone, if you are a guarantor for someone, and the creditor basically clears the debtor, is the clearance of the debtor a clearance of the guarantor? Yes. Is the clearance of the guarantor a clearance of the debtor? No. Okay, everybody got this. Now that's easy. This is an easy one. Now, in the 8th qaida of Imam ibn Rajab, he says, من قدر على بعض العبادة وعجز عن باقيها هل يلزمه الإتيان بما قدر عليه منها أم لا? If a person is able to perform part of an act of worship but unable to perform the rest, is he obliged to perform what he is able to or not? He says that there are several categories. If the part that he's able to perform is not intended, but a mere means to the part that he's unable to sujood. Which part, like, putting your hands is a mere means to putting your forehead. But there are other examples as well. Moving your tongue in recitation. They require you, when you recite, that you're not reciting like in your heart. They require you, when you recite al-Fatiha, that you're moving your tongue, okay? But what if you cannot recite al-Fatiha? You have to move your tongue. No, because it is meant just, for the recitation. Also, we have two types of what was basically meant to be obligatory as dependent of another obligation. One, if it is required as a precaution to ensure that the act of worship is realized. Washing above the elbows, required as a precaution. When you wash your arms, you are required to wash a little bit above to make sure that you washed all of your arm. So, because if you try to wash up to the elbows only, you may miss part of your arm. So you are required to go up a little bit to ensure that you have washed all of your arm. So what if your arm gets cut off at the elbow, God forbid? Do you have to wash the head of the elbow in this case? Two positions in the madhab. One said, the formal one said, yes, you have to. Now, another example is if it is required as a dependent for the sake of completion, as the stoning of the Jamarat and spending the nights in Mina for one who did not perform Hajj. So if you missed Arafah, do you still go ahead and stone the Jamarat? Two positions, but yes, the madhab says no, you don't have to. But there are actually two positions. Next is قد يثبت الفرع دون الأصل. Okay, now we will give you a qaida that's an exception from the previous qaida. The branch may exist without the principle. The branch may exist without the principle. We've given one example on this, the custody example, right? The branch here exists. The mother of the father can ask for custody even if the father abandons his right to custody. But another example is, the validity of the salah of the ma'mumeen. There is one case where the invalidity of the salah of the imam will not affect the validity of the salah of the ma'mumeen, the congregants, the followers. So we said if the imam breaks his wudu, the ma'mumeen will have their wudu broken, right? What if the imam prays without wudu until the salah ends, and none of the ma'mumeen knows that he broke his wudu? And after the salah ends, the imam says, wait a second, I think I didn't make wudu, or I think I don't have wudu. In this case, will we validate the salah of the ma'mumeen? Yes, we will validate the salah of the ma'mumeen. So here, the imam who's al-asl, his salah became invalid, but we validated the fara' or the branch, which is the salah of the ma'mumeen. And here, they must have internalized al-mashaqqa tajlib al-taysir. They must have internalized that. Why can we really invalidate all of these salawat? because that's not something that happens infrequently, where the imam remembers, well, I didn't make wudu or not. Next is التابع لا يتقدم على المتبوع. The subsidiary does not precede the principal. So التابع in general comes after al-matbu' ontologically, in reality, in existence, you know. So in rulings, it should also not come before the matbu'. It should follow the matbu'. And you have different renderings of this قاعدة. المشروط لا يتقدم على شرطه. That which is conditional may not precede its condition. المسبب لا يتقدم على السبب. The effect may not precede the cause. The cause comes before the effect. So this is just, you know, basic common sense. It's the implication of subordination. The implication of subordination. Well, let's take one example. Can you precede your imam in the salah? Of course you can. Can you precede? Does this apply to time only, or does it apply to time and location? According to the majority, it applies to time and location. You cannot pray, you know, in front of your imam. You cannot pray in front of your imam. So it applies to time and location, and that's according to the majority. And the majority here is what? Hanafis, Shafi'is, and Hanbalis. The Malikis said that you may, you know, because it's not about where you stand, it's about whether you're able to follow the imam or not. And Imam Taqiyuddin ibn Taymiyyah took a sort of a middle position, and he said you may, if there is like an intense need, like a need for this, such as in like extremely crowded places and so on and so forth. And that is the position that they go by nowadays when you see Sheikh al-Sudais or one of the Imam of al-Haram praying all the way in the back. They're not always praying at the Kaaba nowadays. Sometimes they pray in the back. This is the position that they are going by, sort of the Maliki position. Next is من ملك شيئا ملك ما هو من ضرورته. Whoever owns a thing owns also what is necessary for it. So if I sell you a property, and rationally or customarily, this property comes with, you know, subsidiaries, like then the sale, even if the sale contract does not name everything that comes with the property, everything is included. Because if I own the property, I own everything that is necessary. So like when it comes to real estate, for instance, installed doors would follow, frames would follow, the ladder that is nailed, and the nailed shelf, fixed millstone, everything that is part of the house will follow. Of course, the furniture will not follow. Treasure that is there, that is buried, a buried treasure, will not follow, because that is not one of the sort of necessary parts of the house. And then anything that is detached will not follow. Here, they mentioned something quite interesting. They said a key does not follow. Remember in the past when I told you if you sell a car, the key will be part of the contract, even if it is not included. So why are they saying that the key here does not follow? You know, in their times, you know, the key was not really that, you know, keys were not very specific to the locks, you know, like in our times, that every lock has its sort of specific key. So you could easily get a key for the door. Like you could easily get, like, if I sell you my house, you know, and I want to keep the key, you could easily get another key for the doors. I mean, it didn't mean that they did this all the time, but they're just saying that the key is one of the movables that will not follow. It's not something that is like, it's not like a ladder that is nailed or a shelf that is nailed or a fixed millstone or installed doors, etc. And if a group possesses the established right of irrigation from an unowned river, okay, so, my land is here, and there is a river that's going, okay. This is a river, this is my land, and the river moves in this direction. You know the concept of Ihya al-Mawat, reviving barren land, and we said that the majority would allow you to revive barren land, no questions asked. The Hanafis will require you to get authorization from the state to revive barren lands, but the Hanafis will say that when the Prophet ﷺ said, "Man ahya ardan maytatan fahiya lahu," whoever revives a barren land, it is his, he was talking to the individuals, like the public, or he's talking to the authorities. He's talking to the authorities. So he's saying to them, let them do it. Grant them license to do it. And the Hanafi position is certainly the position that's suitable for our times nowadays. Certainly the position that's suitable for our times, because otherwise everybody can grab whatever land that they want, and you have big companies and multinational companies and so on. Everybody can grab whatever land he wants, revive it, put a fence around it, and claim it. So, all Muslim countries realize that this is not going to work out. Okay, so and that's the beauty of disagreement and diversity, because sometimes, in parts of the history, working on the Maliki or the Shafi'i position or the Hanbali position was not a big deal. So much land, and just go ahead and claim it. But anyway, so the concept of reviving barren land. So this is the land, my land here. What if someone claims a land here, revives a land here, and claims it? Can they redirect the water, or not only redirect the water, can they water before me? Do they have a privilege to water before me? No, they don't. No, they don't. Because my right has been established before them. My right has been established before them. And in this case, مَنْ مَلَكَ شَيْئًا مَلَكَ مَا هُوَ مِنْ ضَرُورَاتِهِ. Whoever owns a thing owns what is necessary for it. And that little creek was necessary for, my land. So I own this. I own that little creek that was watering my land. If you revive a land that is closer to the head of the creek, that does not mean that you will have the right to water before me. I have the right to water before you. Oh yeah, of course. All of these things are... Yeah. These are very practical issues. The last subsidiary qaida that we will go over under taba or the dependent follows is ma buniya ala batilin fahuwa batil. What's built upon falsehood is in itself false. Okay. So the 53rd qaida min al-Qawaaid al-Sa'diyya says the following. And keep in mind that I did not choose this as the title for the qaida because the title that I chose, مَا بُنِيَ عَلَى بَاطِلٍ فَهُوَ بَاطِلٍ, is proverbial. And when you have a proverbial title of this nature, you will have to use it because it's easy to remember, it comes to mind, it has the power, the proverbial power. But then الشيخ السعدي رحمه الله said إذا تبين فساد العقد بطل ما بني عليه وإن فسخ فسخا اختياريا لم تبطل العقود الطارئة قبل الفسخ. So if the invalidity of a contract becomes clear, what was built upon it, what is built upon it is nullified. Yet, if it is annulled voluntarily, then incidental contracts that occurred before the annulment are not invalidated. We will take examples to make this clear. However, the beauty of the phrasing of al-Sa'di is what? It's detailed and it points out, nuance that the Qaida does not capture. It captures nuance the Qaida does not capture, but it is limited in scope and it doesn't have the proverbial power of the Qaida. So let's just remember ما بني على باطل فهو باطل, and then qualify it afterwards. What's built upon falsehood is itself false. A huge qaida, of course, and as we said before, that التبع يسقط بسقوط المتبوع, where good deeds, الأعمال الصالحة, basically are nullified by the nullification of Iman. This qaida also serves the same meaning. ما بني على باطل فهو باطل, which was basically built upon falsehood is itself false. Whatever you build without a foundation of Iman is like nothing, fluff, will not basically count. Of course, this is like a matter that should be well known to all of us. But close to, okay. So let us take, one example. When the asif that who committed the fornication with a woman, and then there was a settlement between the husband of the woman and the father of that worker, or that asif, that worker, and they made a certain settlement, and then they came to the Prophet ﷺ, told him, that these two committed the crime of fornication, and the Prophet ﷺ nullified the settlement, and the Prophet ﷺ ordered, the had to be established, and nullified the settlement. So they take this example to say that whatever is built on falsehood is in itself false and will be nullified, will not be consequential, will not be approved or established. So let's take a few examples. Let's take this example from al-Mughni. In the event that we judge the contract to be invalid, ownership is not acquired thereby, and all the dispositions of the buyer through sale, gift, manumission, or otherwise will not take effect. So if the contract between me and you is invalid, you sell me a property, and we figure that this contract is invalid, and then you take that property, you sell me, your laptop. I am the buyer. I give you $100 for your laptop. I take the laptop and I sell the laptop for $120, or I give it away, or whatever it is, Now, so is my disposition of the laptop valid? Look, if the contract is invalid, is my disposition of the laptop valid? No. ما بني على باطل فهو باطل. That which is built on falsehood is false. It's invalid. and we will talk about how we will figure out this. But that is why the al-Qa'ida al-Sa'diyya adds this nuance, because there are two different scenarios. One scenario where the contract itself is invalid at the inception of the contract, at the inception of the contract. There is another scenario where the contract is voided later on. Voided later on. How could it be voided later on? Fasakh al-ikhtiyari. It's optional revocation of the contract. Optional revocation of the contract by what? A defect in the product. And I go and I have, I use the option of defect, or an agreed upon muhla or period, grace period, and or taqayul. Taqayul is mutual recession of the contract. We both agree, to void the contract. We both agree to void the contract. This is called optional, voiding of the contract. So if I sold the property meanwhile, what happens in this case? Is my sale of property or gifting of that property, my disposition of the property, valid or invalid? Valid. Because in the madhab, the right position in the madhab is that this revocation of the contract that happened later on, this contract itself is a sahih contract, is a valid contract, versus the previous example where the contract itself is an invalid contract. This is a valid contract. We later voided it by an option or by taqayul, mutual recession of the contract. So we later voided it. Any disposition of the property between the contract and the voiding of the contract that happens later on is valid in the second case, not the first case. Because in the second case, this happens, it says here, okay. The correct position of the madhab is that the annulment which occurs voluntarily because of an option or mutual recession constitutes a dissolution from the time of annulment, not retroactively. Not retroactively. So the dissolution happens from the time of the annulment, not retroactively. So here, valid contract, voided. Voided, why? Because of mutual recession or option. Or, option of also khiyar al-aib, option of defect, okay, or anything. Mutual recession is called taqayul. Taqayul, when we both agree to void the contract. Both agree to void the contract. No, because if there is a defect, I take the property back to you and I say this property is defective. So if we don't have to agree, because I can take you to court and force it on you. Force the voiding on you. But here there is taqayul, means that we both agreed to void the contract. It's not about a defect, it's not about something that I can force on you. It's about an option that I am entitled to. It's about a mutual agreement to void it. Yeah. Yeah. So what if you have an invalid contract? Okay. Disposition by the buyer happens here. Disposition by the buyer happens here. That disposition by the buyer will be validated here, will be invalidated here. Will be validated in the first case because the contract was valid. The fact that we voided the contract afterwards, that voiding of the contract afterwards is a dissolution of the contract from the time of annulment. And this is a matter of disagreement inside the madhab. Since we voided the contract, do we treat this contract as void from the time of inception or from the time of annulment? We treat it as void from the time of annulment, according to the stronger position in the madhab. And it doesn't retroactively invalidate the contract. So it wouldn't invalidate the disposition by the buyer that took place between the contract and the annulment, because between the contract and the annulment. Okay. Let's take a few examples. Make it a little clearer. We took one example from the Mughni where he said, invalid contract. Everything that you do afterwards, whether you dispose of the property by manumission, even manumission, manumission, gift, sale, whatever disposition of the property, all of this is invalid because the contract is invalid. Transfer of ownership did not take place. You bought it, but it is illegal. The contract is invalid. So you didn't acquire it. You don't own it. Transfer of ownership did not happen. Here, transfer of ownership did happen. It was a valid contract. The fact that you voided it afterwards does not mean that in this interim, in this time period, it was an invalid contract. It was a valid contract then. And the annulment will take place only from this time. Okay, in al-Kashaf, he says, so if the buyer transfers the seller with the price, and the sale turns out to be void, the hawala is void. The hawala is void. So the buyer, you sell me, I tell you, Hassan owes me $100. Get the money from Hassan. This is called what? Hawala, transfer of that. Hawala, transfer of that. Now, if the sale is an invalid sale, then the hawala will be invalid as well. The hawala will be invalid as well. So you cannot come back and say, you cannot come back and say, well, this sale is not a good sale. This is the laptop. Okay, here is your laptop. Where is my $100? I told you, get your $100 from Hassan. So that transfer, that hawala, will be voided as well. So let's take some exceptions, and then we will come back and put things together. Among the exceptions is the establishment of lineage in the case of intercourse under mistaken belief. We're saying ما بني على باطل فهو باطل. That which is built on falsehood is in itself false. So what about the establishment of lineage if there is nikah shubha, intercourse under mistaken belief? Is the lineage established? It is established. So why are we making an exception here? Keep in mind that this teaches us one thing, consistency, we're not, slaves of consistency. It is not, you don't have to be consistent. People who are like consistent all the time are people who are very inconsistent, or people who have limited intelligence, because there are always competing considerations. And if you do not make room, if you do not accommodate the competing considerations, and you're trying to be tunnel visioned and just consistent, then that's stupid, you know. Here, they basically did away with the qaida, with the maxim, مبني على باطل فهو باطل. This is nikah shubha. This is not a real nikah. But since it was a nikah based on a mistaken belief, then we will establish the lineage. And what is the factor that is given a higher priority here? تشوف الشارع لإثبات النسب. We say تشوف الشارع للحرية. The lawgiver's eagerness for freedom, liberty, manumission. That makes us prioritize any rule that will lead to manumission. There is also تشوف الشرع, the lawgiver's eagerness for establishment of lineage. The lawgiver wants every baby to have lineage. So we try to work around things and to do our best so that every baby has a lineage. Yes. So if the nikah is not an invalid nikah, but there was like mistaken belief or something, then the paternity will be established, and this father will be a father for the child, responsible for the child, will establish the paternity, but we will not establish the relationship between the man and the woman because the contract is invalid. Now, take another example here. If a usurper, that's ghasib, someone usurps, seizes by force a land, and then grows crops on this land. And now I am the owner of the land. In the middle of the season, I claim my land. What happens with the crops? Okay, actually it is, quite a surprise, because a ghasib usually is treated with like strictness and discipline, but here they will tell you, take the land, pay him the expenses, take the land and the crops and pay him the expenses, whatever he put into the crops, or take rent from him until he harvests his crop. Okay. Their justification of this is a qaida that says, لَيْسَ لِلْمَظْلُومِ أَنْ يَظْلِمَ غَيْرَهُ. It is not permissible for the wronged to wrong others. So you have been wronged, but now, the crops, keep in mind that there is a difference between this, as we have explained before in Umda, and as we have explained before, between crops and trees. Trees. So we said that we will actually force him to pull out his trees, and we don't care. But crops, the scholars said Well, this is a matter that can be easily contained without causing harm to anyone. You know, ليس للمظلوم أن يظلم غيره. The one who was wronged may not wrong others. I can basically figure this out easily, contain the problem, take the crops and pay him the expenses, just the expenses, or let him rent it until he harvests the crops. But why should I destroy the crops? You know, the trees will be there on my land forever, you know, but the crops, it's just one season. Why would I destroy the crops if I can figure out a way to resolve this problem without harm to either party? In this case, ما بني على باطل was not باطل. Okay, so keep in mind that the غصب was not always. Sometimes غصب would be based on a misunderstanding. We disagreed over the land markers, you know, and I took, you know, a little piece of your land. Sometimes, you know, we disagreed, but then I forced my way, and then it would be considered forceful seizure because I believed that I had some right or some entitlement to this land. It was not always that the ghasib was just like so evil. Sometimes the ghasib would be mistaken himself. And, you know, what they were looking at here is trying to figure out a way that we don't destroy the crops because that makes no sense. And we basically give everybody their dues. And we're gonna just pay him the expenses. But you can disagree, that's fine.
You said ghasb?
Ghasb, forceful seizure of the land, usurpation, usurp. Sin or Sad? Sad. Sad. Oh, no. Okay. Next. So the correct, okay, I told you the correct position of the madhab is that the annulment happens at the, like optional annulment here, happens at this time or this time, happens here at the time of annulment, not at the time of the inception of the contract, not retroactively. Thus, the transactions that took place between the contract and the annulment are upheld. Thereafter, the first buyer, after disposing of the commodity, must pay the first seller the like in fungibles and the value in non-fungibles, and he recovers his payment. He recovers his payment. Okay, now, we said that I disposed of this property, and then, you know, I got the laptop from you for $100. And then I took that laptop and sold it to Cherno, for instance, for whatever money, well, you know. Then you and I, taqayanna, basically mutual recession of the contract, or for whatever option, we voided the contract. We voided the contract. Who has the laptop now? Cherno. Now what do we do? How do we, like if this is void, what do we do? You're going to give me the $100. I gave you $100 for the laptop. You're going to give me the $100, but where's the laptop? And did we validate that transaction between me and Chernu? We validated it. Transfer of ownership happened or not? Happened. So I'm not retrieving the laptop anymore from Chernu. What happens? I have to pay you the, No. Okay. Yes. I have to pay you the value of the laptop, fungibles. If it is fungibles, then I have to pay you the mithl. If it is non-fungibles, then I have to pay you the value. The last part. And the remainder of what, okay. Okay, so remember when I told you that the hawala, the transfer of debt is invalidated if we invalidate the contract, and we read part of the kashaf. If the contract is invalid, any transfer of debt will be invalid consequently. But what if there is a hawala here? What if there is a hawala here, and then we void the contract here? This is a valid contract. Hawala takes place here, transfer of debt, and then we void the contract here. Is the hawala voided? No, the hawala is not voided because the contract itself is valid. So the bottom line is the contract can be void at the inception because the contract is inherently invalid. The contract may be voided afterwards by options or mutual recession or other causes of voiding the contract. If the contract was invalid at the inception, every disposition of the property that happens afterwards is invalid. ما بني على باطل فهو باطل. That which is built on falsehood is itself false. If dispositions happened in a contract that was validated but later voided, all the dispositions that take place here will be valid dispositions. قولوا قولي هذا واستغفر الله لي ولكم سبحانك اللهم وبحمدك اشهد ان لا اله الا انت استغفرك واتوب اليك.